Well, hello there. Hold on. That's better. Hello there. How is everyone? I hope you're all well. This is video 2 of 3. And later on, I'm going to say this is video 2 of 2, when in fact there is 3. Because this is an extra one. Because we've got some new docs dropped. And I just wanted to go through them with you because you're amazing people and you deserve it. So shall we do it? Let's have a look. All about DNA. We're going to go through it. So in the District Court of the 2nd Judicial District of the State of Idaho, in and for the County of Latah, response to state's notice of intent not to cross-examine defense witnesses, District Court decision and records to explain witness contact. Comes now Bryan C. Kohberger, by and through his attorneys of record, and hereby responds to the state's notice of intent not to cross-examine defense witnesses, District Court decision and records to explain witness contact. Procedural history. This court conducted a hearing on August the 18th, 2023, on Mr. Kohberger's third motion to compel. 4 witnesses testified for the defense, and the state reserved the right to cross-examine 2 witnesses. On August 30th, 2023, the state filed notice that it does not intend to reopen the hearing and cross-examine the 2 witnesses. Okay. Response. Referenced in the state's notice of intent not to cross-examine defense witnesses, District Court decision, the records to explain witness contact, state's notice, are a 3rd District Court transcript from CR for some numbers. Mr. Kohberger's defense team has reviewed the exhibit and provides the following response. At first blush, it appears the issue before Judge Whitney in State versus Dalrymple, that word, CR 1420-07840, was that the state was seeking a protective order relating to a database that produced information leading to Mr. D's arrest. However, the decision Judge Whitney announced was on a different issue and was made without the benefit of expert testimony relating to the forensic investigative genetic genealogy process. It is noteworthy that even without the benefit of that testimony, Judge Whitney concluded that the state needed to turn over in discovery everything in its possession relating to genetic genealogy, and the defense was welcome to bring further motion on the issue. This court is asked to decide something different. The information sought by Mr. Kohberger through his motion to compel is the same information that the state seeks to protect with its motion for protective order. The SMP profile created on behalf of the state and the genetic genealogy process directly used by the state to identify Mr. Kohberger. Mr. Kohberger is not asking for a genetic genealogy database, rather the analysis and documentation utilized to identify him. Mr. Kohberger has also asked for the SMP profile, and the state has agreed to provide it. This court is left to decide whether to shield the analysis and documentation developed and used to identify Mr. Kohberger, or to order it to be provided for his defense. This court makes its decision with the benefit of expert Steve Mercer explaining the duties of attorneys to examine this evidence and the types of legal decisions that could be made based on this evidence. This court has the benefit of knowing, based on expert testimony, how SMP results are produced using bioinformatics. That word. Further expert testimony described how genetic genealogy tracing is conducted and the documents generated by a genetic genealogist showing the analysis and results. Further, this court has the benefit of expert testimony describing how SMP testing can be compared against STR testing for contaminants and mixtures, as well as how the SMP and genealogical data can impact statistics. Lastly, this court has knowledge of the intricacies of prohibited law enforcement access to various DNA databases. The testimony the court received in the hearing relating to this loophole is not something Judge Whitney had the benefit of knowing. It is important for the court to be aware that this same information has now been published on August the 18th, 2023 in The Intercept. This article details forensic genetic genealogy and the loopholes utilized to obtain information in contradiction of authorization, attached as Exhibit A. The Intercept is an online journal that has existed since 2014. Open source information states this is an award-winning news organization dedicated to exposing the powerful and holding them accountable. And it goes on here. The court, State versus Mr. D, also lacked the following documents that established a relationship between the Idaho State Forensic Laboratory, local police departments, and prosecuting entities in the state of Idaho. This court received such documentation attached to the declaration of Ann C. Taylor in support of third motion to compel. The agreement is attached again, herein as Exhibit B. This memorandum shows that Idaho utilizes federal money to work with Othram laboratories to identify suspects in certain cases. This memorandum shows the intricate relationship between agencies for identifying which cases qualify for identification through genetic genealogy. In Mr. Kohberger's case, the LaCar County prosecutor, the Moscow Police Department, the Idaho State Police, and the FBI worked together to investigate the case and identify a suspect. At some point, genetic genealogy was utilized for identification. That information remains withheld from Mr. Kohberger. Mr. Kohberger does not even know when this began or when he was supposedly identified. Neither do fucking we, and that's the point, isn't it? The memorandum contains a requirement that the Federal Department of Justice policies, hereinafter DOJ, must be adhered to, and that agencies must sign a memorandum of agreement to follow such policies. The DOJ has a policy regarding forensic genetic genealogical DNA analysis and searching. What a mouthful. This policy was attached to Taylor Deck in support of third motion to compel, and is again attached herein as Exhibit C. That policy requires that the prosecutor and the investigating agency collaborate, see page 5 and 6. That policy also requires that investigative agencies only enter and search DNA databases that permit law enforcement to use their services. That policy requires that all forensic genetic genealogy profiles, account information, and data shall be retained by the investigative agency for potential use during prosecution and the subsequent judicial proceedings. There is a relationship between local, state, and federal government to work together. DOJ policy requires retention of analysis and materials for use in judicial proceedings. This knowledge, in addition to the potential for misuse of information, is something that is discoverable and necessary to Mr. Kohberger. And they've put the rule here. Idaho Rule of Criminal Procedure reads, the prosecuting attorney's obligation under this paragraph extend to material and information in the possession or control of members of prosecuting attorney's staff and of any others who have participated in the investigation or evaluation of the case, who either regularly report or have reported in that case to the officer of the prosecuting attorney. The duty of disclosure is an obligation of not just the individual prosecutor assigned to the case, but of all the government agents having a significant role in investing and prosecution the offence. State versus Gardner, and they go through this other case. The FBI has been compelled to turn over its CAST report relating to cellular data evidence and its investigation related to identification of the car. The investigation related to the car included hundreds of names of individuals owning a white Hyundai Elantra. The evidence held regarding DNA is no different. The court in Mr. D's incorrectly permitted the state to hide material from the defense by claiming they did not have it. That is not how discovery works. When the state decides to work with outside agencies to take liberty from someone, this court has thus far shown that the FBI does not exist outside the discovery rules. It should not grant them immunity now. Conclusion. The transcript provided from the Judge Whitney does little to instruct this court about what should be decided. This court has a different question. Mr. Kohberger requests materials and analysis, not a database. These materials are required by the DOJ to be retained for use in judicial proceedings. This court has the benefit of understanding the process and the materials that were created in this identification of Mr. Kohberger by the state and its agents. Mr. Kohberger respectfully requests the court order the state to disclose the materials. Mr. Kohberger is happy to comply with any limited order the court deems appropriate. Well. And then they go through some of the stuff that's been place in that article I spoke earlier on about, which talks about how law enforcement are basically using databases and obtaining information without people knowing. And there's a fair bit of it. I know I'm scrolling through, but you can obviously pause the video at any point. I will scroll all the way through just for that reason, so you can pause it if you want to read. I'm not going to read through all of that because this video would be about 3 hours long, and we don't want to be doing that, do we? That's a long video. In fact, can we speed this up a little bit? Like I say, I'm only doing it so you can pause it. You might not even be interested in it, but look, it's here. I know some of you, not everybody, has access to this documentation. So I'm just kind of making sure that you have it. And we've got some stuff here at the end. There we go. Feel free. These are some of the stuff that they have attached, the exhibits on the end. You might find that Mr. Sexy Lawyer, he may go through all these bits a little bit more in depth. You know me, I'm unprofessional. Just going through the docs for you guys. So there you have it. That is pretty straightforward. This is basically the defense turning around saying, look, we've pissed about, we've farted about, we've danced around this subject for too long already. We want discovery. We want everything that our client is entitled to, and we want it now. You've got all the information that you need, which is proof that it's something that you need to hand over, so get it handed over. Let's crack on and get this sorted. Let me know down below what you think, and I'll catch you in video 3 later. Don't miss it. See you later.